Honorable Mr. Justice Amritsar, former Chief Justice of Punjab and Haryana High Court, Honorable Justice Banerji, Administrative Judge of Amritsar, members of the District Judiciary, members of the Bar Council, and members of Bar Association. It gives me immense pleasure to come and participate in this conference in this holy city of Amritsar. Today's topic relating to the district courts being at the heart of Indian judiciary is a topic that is very close to my heart. The district judiciary, as we all know, is the first point of contact between the litigant and the judicial system. Approximately 90 to 95% of our cases in India are initiated in district courts. Therefore, the district judiciary can truly be called the heart of the Indian judicial system. District judiciary, as you all know, deal with a wide range of matters, from criminal offences, family law cases, and serve as a guardian of our constitution and protector of fundamental rights of the citizens. It is usually a common notion that the High Court under Article 226 and the Supreme Court under Article 32 protect the fundamental rights of the citizens. But the district judiciary is doing so every single day by protecting the life and liberty of the citizens. The district courts are no doubt doing a commendable job in protecting the life and liberty of the individuals, keeping the heart of justice beating, despite several constraints. Today we need to focus on how this heart can beat stronger and louder. Much has been said about the backlog of cases in our country before the district courts. Let us now focus on the goal of ensuring speedy and effective trials by adopting a permanent and pragmatic approach. Since the litigant-judge ratio is poor in our country, leading to overburdening of individual judges with multiple cases of the same thing, it is imperative that the strength of the judges be increased. In the Lok Sabha session of February 2024, the Minister of State, who has independent charge of Ministry of Law and Justice, Sri Arjun Ram Meghwal, answered this question with regard to the judge population ratio in our country, which approximately works to 21 judges per million population. The Supreme Court of India in Imtiaz Ahmed versus State of Uttar Pradesh had observed that there should be at least 50 judges per million population. I do agree that the district judiciary's sanction strength has been increased from 90,000 and odd in 2014 to 25,000 and odd in 2023. And the working strength has also been increased from 15,000 in 2014 to 20,000 in 2023. But a significant more is desired to be achieved, as India has not yet achieved even 50% of the recommendation. Next is the issue of inadequate infrastructure in varying the functions of the district courts, particularly in rural areas. As the administrative judge of Rupnagar, I was informed by the principal judge in family court that the courtroom where the family cases are being heard was inadequate, and in the Hon'ble subdivision, there were not even washroom facilities for the judicial officer who was holding court from morning till the afternoon. The moment this issue was brought to my notice, I took this up with the Building Committee of the High Court. And now I am informed that adequate funds have been released by the government for construction of a new court building, courtroom, and retiring facilities and washroom facilities for the principal judge, who is a lady and holding court in Hon'ble subdivision. Therefore, any kind of inconvenience that is faced by the judicial officers should be immediately brought to the judge so that the issue can be suitably addressed. We need to understand unless adequate facilities and infrastructure are provided to the judges, district judiciary will not be able to perform at the optimum level. Since district judiciary is at the heart of the judicial system, the state government also at all times need to provide the best infrastructure so that a judicial officer can deliver justice efficiently and quickly. Next, I would like to highlight the importance of maximization of judicial time. As Justice Wazutar was saying, that administrative function is a very, very important part of the judicial work as well. But I would like to see that certain administrative work that is performed by the district judiciary may be handed over to a trained administrator, and the state government might like to consider a proposal regarding that. Because if certain amount of work can be handed over to the trained administrative officer, it will lead to freeing up of the judicial time, and the judicial officer can get on with the day's work smoothly and effectively. I also urge the district judge of each district to ensure that the economically backward and other marginalized sections of the society are aware of their valuable legal rights, and the legal facilities are made available to them. One should be compassionate to reach out and protect the weaker sections of the society, albeit within the confines of law. Today in the morning, Justice Suryakanti was mentioning about a compassionate and humane approach to justice, and this is what we should all keep in mind. It is important for all of us to keep in mind that judges, whether at the district level or the judges who are a part of the higher judiciary, are all serving the citizens. Therefore, no doubt should ever be raised with regard to the integrity. Transparency and accountability are qualities which should be prerequisite for holding such posts of immense responsibility. Faith of the citizens in judiciary should never be dented due to our own actions and conduct. We have to keep reminding ourselves that we are not here to enjoy the perks without doing commensurate work and delivering corresponding work. So rights and duties are two sides of the same coin. Therefore, I appeal to the conscience of all the judicial officers to perform their judicial work without any fear or favor and rely on one's own conscience in upholding the constitutional values. The district judges and other judicial officers are also required and requested to update themselves with regard to the law on the subject. Sometimes we find that the judgments are being passed without considering the text of the statute or the law laid out by the Supreme Court, which we are required to follow under 141. I would like to give certain examples, one or two illustrations maybe. Sometimes we find that under section 428 of the CRPC, the new 468 of the NSS, sentences being pronounced without setting off the period that an under trial spends in custody in the same case. Now this has to be kept in mind. One should realize that the text of the statute and the law laid down by the Supreme Court in this case of state of Maharashtra and Nagara, as well as the recent case of Vinay Prakash Singh, which clearly says that set-off is duty granted to a convict in a criminal case if he is spent time as an under trial in the same case. Now I would like to focus on Amritsar being a model district and its suffering from the menace of drug addiction. I agree that drug gravely affects the youth of our society. However, proportionality has to be looked into. We are trying to approach the judicial system from the reformative point of view, one needs to keep in mind that a convict who has been convicted of carrying contraband, that convict cannot be equated with a convict who has been convicted of carrying a huge quantity of heroin. So these things, a compassionate approach is required by the district judiciary, and these things have to be kept in mind and looked into from the aspect of proportionality. The judiciary, all its own cannot ensure speedy and effective justice to the litigants. The lawyers being officers of the court have equal responsibility in participating in the judicial work, assist the court in speedy disposal of cases. The junior lawyers, this is for the junior lawyers, junior members of the bar, you all need to be well prepared with the facts and on the law, and not seek adjournments on behalf of your seniors. In a bail matter or in a suspension of sentence case, once an adjournment is sought, due to the pendency of the work, your turn might come after a month or two. So then, what happens is that the liberty that is guaranteed to every citizen under Article 21 of the Constitution of India has to be sacrificed or will be put at stake. So please be prepared on the day when you have a matter. Sitting in the criminal roster, I have realized that the state of preparedness of a lawyer on a particular day when his or matter is called on is of crucial importance. One should never ever let this opportunity pass. Another important aspect is the issue of suspension of work by the lawyers. Please try to take a pragmatic approach, because you have to realize that unless you participate wholeheartedly, it is not possible for the judiciary to deliver speedy and effective justice. Unless there is effective participation from lawyers, the district judiciary will almost find it impossible to meet their target in action-plan cases. Certainty is required to ensure the hearing of the cases on the day they are scheduled. Sometimes too many cases are listed on one day, or the witness who has to be cross-examined has not come to the court, or the lawyer who is supposed to cross-examine or examine the witness is engaged in some other mode. So all these things create a dent in the confidence and faith of the litigants in judiciary. Let us all try to minimize this uncertainty and increase the speed of the justice delivery system. In civil cases, litigants should also be encouraged to resolve their disputes through alternate dispute resolution proceedings. Mediation, conciliation, and arbitration proceedings should be suggested to the litigants to reduce the burden of the district justice courts in matters, in civil matters. And also, Lok Adalat is also a very effective measure for disposal of cases, and lawyers should definitely wholeheartedly participate in such proceedings. Whenever possible, disputes should be amicably settled to save time, energy, and economic resources. And also, the lawyers, as officers of court, should discourage litigants from filing frivolous appeals or litigations, therefore clogging the justice delivery system. Because sometimes what happens is that delayed justice will lead to denial of justice. I have myself come across cases where the poor litigant has died in incarceration because the court did not find time to take up the appeal. So kindly behave as officers of court, I urge all of you, and discourage people from unnecessarily getting into frivolous litigation. To conclude, I would like to say that effective cooperation between the members of the bar and judiciary ensure life and liberty of every citizen being protected and justice being dispensed to them quickly and effectively the heart of Indian judiciary meeting strongly. Thank you.